So, Mr. Cohen, as before we went on break, we discussed that the specification and/or the design OceanGate blueprint that you had built your acrylic window to was the TAC 040, TAC MEC, TAC 000461 Rev B, dated 10/10/2017. And if we can go back to the other drawing as well, if you'd like to.
I can see it. I understand your question.
And was that a yes to that's what you built your window to?
That's a drawing I have on record, and I believe yes.
Okay. So while I know that you did not build this one from the Heinz Fritz company from this quote from April 29th, 2020,
No.
as a engineer of acrylic windows, is there any way for the rated depth to be increased within the engineering other than changing the shape of the window?
If they have the testing documentation that they performed the PVHO test on that first window, that would allow them to create a Form VP2 qualification by testing, and then they could qualify it as PVHO without having a signed VP2 or documentation at the company at OceanGate that they've performed that testing and verified it. Then it would be a copy of the original test window. It wouldn't have any pressure rating any more than what we determined it to be at 945 PSI.
Thank you. That's all the question I have for now.
Mr. Kohnen, I have some follow-up questions on the testing that you mentioned earlier. I believe you said normally there would be tests of 5 windows to failure.
Yes.
Would you normally perform those tests, or would that be operationally tested by the buyer?
It is available. We offer that for people too. It is extensive. So that can be contracted out under contract, or it can be performed. A lot of times, because of the expense, the clients would choose to do that themselves, but it is a service we could provide.
And would that testing have to be done in a seat similar to the Titan's dome? I mean, the seating surface?
Yes, that is one of the requirements on the testing, is that the interface that the window sits into be identical to the design that is used in a vehicle.
And how would you fabricate that, sir? Or would it be done on the actual, or would you just build a mock-up of the?
You would typically build a mock-up specifically for the testing that ensures that the interface is identical.
Sir, early in your testimony, you testified to, I believe you were referring to Navigation and Vessel Inspection Circular 593. We call it a NAVIC.
NAVIC 593, yes, sir.
Was that the specific document you were referring to when you talked about your early interactions?
Yes.
And is it to your understanding that that document is still in effect at this time?
Yes. It is. It works in conjunction. It's the NAVIC 593, and then the follow-up, a NAVIC 794. That is the Passenger Vessel Act of 1993 that was passed, that enacted into law the release of NVIC 593. We'll talk more about it after lunch.
Yes, sir. Thank you. At this time, does the NTSB have any questions?
Not right now, Chair. Thank you.
OceanGate, realizing this, we're going to have Mr. Kohnen back after lunch. Do you have any questions at this time?
I think we can hold them until after.
All right, Mr. Kohnen, we're going to adjourn for a lunch, and I understand you're going to be coming back for an afternoon session. At this time, we'll be in recess and reconvene at 1:40. Thank you.
Thank you very much.
The hearing is now back in session. Before we continue with testimony with Mr. Kohnen, I want to clarify one issue for the record. The viewport that was used on the Titan during the accident dive was actually manufactured by Heinz Fritz GmbH in Germany, and that was manufactured on delivered to OceanGate on July 14th, 2020. At this time, we will continue with questioning from Lieutenant Commander Williams.
Good afternoon, Mr. Kohnen.
Good afternoon.
Would you ever consider building a carbon fiber hull for one of your submersibles?
No,
Why not?
too much money, not worth. You have to, a submersible must have a minimum weight to be able to sink. If it's super light, you have to add lead to it to sink it. To go super deep, steel gets a little too heavy, but the carbon fiber, all the angels today say this is really, really difficult. The Navy has spent more money than any private company has available to do R&D on. Still not doing it. So leave it to the Navy to figure out first before we would do it. Not practical commercially. Wouldn't do it.
Did you ever have any conversations with Mr. Rush regarding his business plan or company vision?
Not beyond the general vision of democratizing the ocean, which is join the club. I mean, we're all trying to bring access to the ocean, but nothing beyond that.
What are your thoughts on the term mission specialist? Who pays a company like OceanGate for a seat in a deep sea submersible?
Well, that's a lengthy conversation. It is a problem, but it is deeply rooted in problems that lie with the current federal regulations on the Coast Guard. I think it is bringing a lot of people to find ways around things because it's too convoluted, and I think I'd prefer addressing that in my second part of the presentation, if you don't mind.
That's fine.
It needs context, that's why.
Recorder, or Lieutenant Steele, could you please bring up Exhibit 068? And this is the draft Marine Technology Society letter to OceanGate dated March 27th, 2018. Mr. Kohnen, are you familiar with this letter?
Yes.
And why did you decide to draft this letter?
This letter came as a culmination of a number of observations within the industry. As I've mentioned before, I've been organizing a yearly conference for 20 years. This was our 15th reunion. It was in 2018 in February. There was broad knowledge across the industry of what OceanGate was undertaking. They'd been doing it for a while, for some years now. Everyone was paying a lot of attention, and it really came to a head at the three-day conference. And many people, it went from, I don't know about it, to serious professional concern that this is really dangerous. And that year happened to be Dr. Segalovich from Russia who presented. Dr. Segalovich ran the Mir submersibles, which probably single-handedly have the most dives on the Titanic wreck, Mir 1 and Mir 2. This is what Mr. Cameron hired to do all the filming. And it was a very special operation to have this twin set of 6,000-meter rated submersibles. And the crew was extremely experienced. And they presented that year just saying how tough some of these operations were. And they also brought up the fact that this is, to say, extremely serious diving around the Titanic, to make a fine point on it. And expressing more than concern, more disbelief of how casually this seemed to be taking, and not understanding just how precarious the conditions are, both environmental and at the wreck of taking the submersible. So all in all, we had a very extensive group of people around the world, and it came said in a meeting, you know, we have to do something about this. In fact, we even had, I believe, you had a question of Mr. Stanley yesterday on some of the conversations about Coast Guard rules, consensus standard, how we do things, and it was a meeting that was in 2018. And we had lots of roundtable discussions on various aspects, and it came out to the conclusion, look, we need to do something. There was a range of things suggested, from lawsuit to just leave it be. And it's like, and that's where it kicks in. You have to make a decision. I believe it is important today, the responsibility we all have. I think the country tries to teach all its citizens, if you see something, say something. Well, it goes both ways, and it applies to leadership as well. And this was considered an issue of where we as consensus, as professionals in this industry, had significant concerns, not on one particular thing, but the overall approach of neglecting the years of experience and tradition and diligence that we applied. So I suggested, look, why don't we try with something simple and write a personal letter to the CEO, Mr. Rush, address his better angels, and say, look, this is beyond sibling rivalry here. This is everybody around the world. It is not a personal thing, and it is not something that we don't want you to do it. Everyone wants you to do it right. So I drafted it. This was the first draft. We had various communications, and I promised, look, I'll make a draft and I'll send it to everybody by email, look it over, make some suggestions. There ended up being multiple drafts of the letter. A lot of people had ideas, things. This was the very first one. And the consensus, well, there was a varied feedback. I was just looking at it again, and not all of it was very polite. Like, who do you think you are? What do you think you're doing? To, I agree. At some point, you have to make a decision, and I figured it was the right thing to do, and we drafted it. We have, out of 4 people, we had more than 24 people sign it. And it was, I made sure that we had representative for just about every country that is a member to represent the global. And everybody knows each other. So I knew that Stockton would recognize these members, and hopefully it would sink in that the professionals on that list would have a meaning to them. That was the impetus to write the letter and to bring up the attention to Stockton that, we are concerned.
Was any letter similar to that ever delivered to Ocean Gate?
No. Well, qualify. Officially, it was not delivered. As chair of the committee, I've been chairman for 20 years. The board of the Marine Technology Society more than once reprimanded me for speaking outside the bounds of the society, says you can't say these things, and it's like, well, this is just something important to the industry. By 2018, I was wiser, and I figured, well, after we had the draft and everything done, I figured I should really pass it by the executive director and the board just to make sure that they're all okay with it. That was a bit perfunctory, but I went through the motions. I was surprised when the answer came back and it said, you cannot. You cannot send it on behalf of MTS. You can send it personally, but not on behalf of the society because we don't know anything about submarines. It is clearly under protest. It's like, well, you have the most advanced organization of submarine scientists under your purview. Of course, we understand what this is. But it was considered outside the bylaws of the nonprofit organization. I had to respect that, and then I said, okay, and I filed a letter. Was a letter received? And that I can confirm it was, because somewhere down on all the electronic letters that were circulated, one of them got passed on to OceanGate, and Stockton got the letter. And Stockton's first reaction was to call me. It was not unusual for Stockton to call me. We talked a lot. And he asked me, well, what is this? And we had an interesting phone conversation about the letter. So yes, he did receive one, but not formally.
Thank you. That concludes my questions.
Sir, can you give some details about the conversation you had with Mr. Rush regarding the letter?
Yeah. I grew up in a big family. We're 8 kids. Everybody thinks is really smart, but you do stupid things, and around the round table, you get told and straightened out by your siblings when you do something. I don't think many people ever told Stockton no. Don't think he understood that concept very much. It was an approach on the letter.
Yeah, I believe the question was about Mr. Kohnen's conversation with Mr. Rush about the letter.
Yes, sir. If you could just, I really am interested in the direct dialogue that you had with him, if you can remember.
I do remember. And on saying what this letter had to do, says, well, you can read the letter. We are all very concerned on the directions you are taking with the company. And there are 3 things we mentioned. Says, first, it is not appropriate what you have on your website. The language is confusing, it is misleading. I read it, I understand what you're saying, but a normal citizen will not understand what you're saying, and you are highly inferring that the vehicle is classed. And they were using the name of DNVGL on their website, and I said, I don't think this is appropriate, you need to fix it. In my conversations with Mr. Pauli in Germany, I said, well, you should be aware that it's on the website as well. I think this is not helping you. And we have to give credit to, and it's like, look, this is not a certified submersible. It's an experimental vehicle. You really need to be transparent about that. And I give Stockton full credit for fixing that. The website was updated, and I believe after that, everybody was fully aware that this was an experimental submersible and it was not classed. So that I was most happy about that. In context, I write many articles, I write many reports in all my professional life. I always imagine that public safety can be achieved through transparency and ensuring that the general public understands and can easily perceive whether a submersible is certified or experimental. And I thought that was a simple way of achieving some public safety. Since then, I must change my mind, because in the case of Titan, it was very, very clear it was experimental and not classed. And the general community of users, citizens, media, seem to completely not understand the implications of this. I thought that was, it was a lesson learned. The report I wrote in 2017, 2018 was published in the MTS Journal. It stands to openness and public availability of information. I do an annual global industry review, and I did not exclude OceanGate. I brought them in and I put in, but I remember choosing the words very carefully. This is still a legal, actionable country, of saying that the OceanGate is building an uncertified submersible. They're not operating under class. To the community doesn't mean much. To authorities, to which that report was also available, and that includes the Coast Guard, is it has a sign. It says, pay attention here, certainly with the awareness of what their intent is. So to say what was the conversation with Mr. Rush on the phone, it's like, okay, you need to fix this and you need to be clear, and that he did. The second part, the second part had to do with the classification. And it was the usual response that it takes too long, it's too expensive, and they don't know about this technology. I don't have time to explain my technology. And it's not doable. And it's like, yeah, no, look, there is a way. You can't just walk away completely. I said there are such things as qualification through testing, as opposed to calculation, is at the very least, you can come up with a validated test program, but you need to have a third party validate your test program. I said doing 2 or 3 dives to 4,000 meters is not a test plan. So that is on letting him offering that there are solutions industry. It requires some ingenuity to be a bit creative, but to find support. And he did say, well, everybody doesn't not like me. It's like, no, Stockton, no. But everybody does want you to do it right. And that's what the purpose of the letter is. You have to do it right because we're all in the same boat. It wasn't registering. In the end, we had to agree to disagree. The parting words were simpler, and he says, well, I am leaving the association. Upset, says, well, you can't. And he says, why not? He says, because Stockton, you never paid to be part of the association. You are a member of the brotherhood. You belong to the community. You have a responsibility to everybody. It's not about a paid ticket. So no, you cannot leave.
Sir, during that conversation, were you or MTS ever threatened with litigation if you sent the official letter?
No.
And just one follow-up, sir. The concerns that generated the need to draft a letter, was that based on OceanGate operations domestically with the Antipodes and Cyclops, or was it based on just the plans to operate the Titan?
Mostly the plans to operate the Titan, the approach they were taking in the development of the program.
Was MTS aware of the other operations that were occurring domestically, the oceanographic research vessel operations involving Antipodes and Cyclops?
I believe so. It's in multiple of their newsletters.
Thank you, sir. Does NTSB have any questions at this time?
My questions all revolve around the role of flag states, but I believe there's a presentation that might answer my questions. Okay, I'll defer then.
Does OceanGate have any questions before we go into the compliance scheme?
Mr. Kohnen, we have a few questions about the MTS letter you just saw. So can you confirm that Exhibit 68, which was just shown on the screen, was a first draft of the letter and that there were subsequent later drafts written?
That is correct.
And do you know which version of the letter was ultimately sent to Mr. Rush?
It was the one on the screen. The other ones never left.
Okay. And could you clarify how many signatories there were on the letter?
Which one? The one he saw, or the final one?
The one he saw,
The one he saw? I believe there's 40 or 42.
40 or 42?
Sir, can I just make one point of clarification? The letter we saw, names are obviously redacted, but there's 6 redactions on that. I just wanted to clarify, it didn't seem like there were 40 names there being redacted.
They're mostly on page 2.
And is that not included?
No,
I think can we go back to that exhibit, please?
There's only one page.
Okay, I can clarify that the Coast Guard only has the draft of page 1, so we are unaware of how many signatures were initially at least given to the draft. So I would have, if you're, by
I'd
your
like to,
memory,
yeah,
sir.
I'd like to add something to that, because that letter wasn't meant to be public. I did not know that it was publicly available. It was only after the incident that the New York Times called me and asked me if this was a letter that I had written. And when I asked, how do you have a copy of that letter? I was told he didn't need to let me know. I says, well, fair enough. I don't know, somebody obviously passed it on. I am not sure if in that activity that brought this letter public, both pages were made public. And I never shared with anybody the second page.
Thank you.
Okay, at this time, sir, I'd like to transition to the presentation that you drafted. We are a bit short on time, so if you could help us kind of accelerate through this, sir?
I think we've covered many things already. I think it'll help expedite.
Yes, sir, thank you.
I appreciate the opportunity to bring this up. This has been a conversation within the industry for many, many years. And it is presented here as throwing observations on the wall for everyone to consider. There is no one answer, but with all my professional experience of 30 years doing this for a long time, paying attention, talking to many people, we could take these as personal observations for the record. This is William Kohnen speaking personally and bringing you what I put together. The first few brief overview is for general benefit, and I know the public has some sort of questions. And what is the industry made out of? How many submersibles go to 4,000 meters? These are some very brief items I put together last summer to brief people in the industry that want to have a better idea what the situation we have in here. Right now, there are 9 submersibles that in the world that can dive to 4,000 meters. It's a limited set. All of them are classed by different classification societies. Titan was the odd man out. There are somewhere today, it's probably updated here, but shy of 200 submersibles operating actively around the world today. And there it shows the first some shallow submersibles all the way down to 1,000 meters. You will notice 1,000 meters comes up very often, just for general public information. 1,000 meters, anything beyond 1,000 meters requires an export license, so it's a bit of a natural barrier. Beyond 1,000 meters, it's considered advanced. The list of the 9 operating submersibles today that go to 4,000 meters includes China, the Fenduse, the limiting factor, and everyone knows with Mr. Victor Vescovo, who went down to the Mariana Trench, Jiaolong from China, Alving in the U.S., Shinkai 6500 from Japan, the Natil in France, Consul and Rus 37 in Russia, and the Deep Sea Warrior. All of them carry 2 or 3 occupants, and you could see the class society. CCS stands for the Chinese Classification Society. DNV is from Europe. We have another slide for those. The general configuration of a deep diving submersible is like shown on the cross-section, and it generally consists of a spherical hull, which many people have. Well, how about the cylinder? Well, if you have a cylindrical pressure vessel, you need 3 parts, 2 round ends and a middle part. If you skip the middle part and you have only 2 parts, the 2 ends, it's just simpler, cheaper, and stronger. Classification Society. When we say that we have experience in the industry of 50, 60 years of events that happen and we make notes, this is playing the computer game and you write notes on how to win. That's what we do, lessons learned. These lessons learned are written somewhere. They are compiled in the rules and regulations that these classification societies put together. And they're non-governmental organizations that operate in different countries, and they all publish their rules a lot of times for free. Don't go too fast forward. I want to, right there. The American Bureau of Shipping rules, for example, this is available to the public. This is available to anybody who wants to look how hard is it to make a submersible. It is free. You might not understand what it all says, but this information is the cumulative action of years and years and years. DNV is a big classification society, so is Lloyd's, and most equally importantly, the American Society of Mechanical Engineering, ASME, that controls pressure vessels for human occupancy. This is a foundation of how you do design around the world for submersibles. We have existing design regulations. Next one is operational guidelines. In the United States, the Coast Guard has existing regulations, which is the NVIC 593, which is the guidance for certification of passenger-carrying vessels. It was released in 1993, and it was put into law by the Circular 794, which is the Passenger Vessel Safety Act of 1993. We even have international regulations under IMO, which is the Circular 981, which is guidelines for the design, construction, and operation of passenger submersible craft. So we have, go ahead.
Sir, I just want to, can you go back one slide, please, Lieutenant Steele? Just for clarification for the record, a navigation vessel's inspection circular is guidance, not a regulation. But in absence of a regulation, a lot of the industry goes by those guidelines. Just want to clarify.
Yes, thank you. I thought for the purpose of the presentation, it is worthwhile bringing, just updating a little bit. These are slides from the presentation in 2006, where there was a lot of work compiling some safety statistics for the industry, and I thought it would be worthwhile bringing these up as background. So there's a lot of talk. The heyday of submersibles was in the 60s and 70s, before all the robotic systems came in. And it turns out, like, well, how many were there really? And you could see here from 1964 to 1965, how many active submersibles were. It's around 40 or so. This slide is important because this is where the last fatalities occurred in our industry in 1970s. Go to the next slide. We have 4 recorded incidents, the Necton Beta in 1970, which happened in California, in 1973 on the Beaver 4 in California. Someone died, but that was a surface accident when the towing cable broke. Johnson Sea Link is probably the what's written most about, which happened in Florida and killed 2 people. And 2 people died in a fire in Japan on the Usushio. This graph over here shows where the fatalities were in the spectrum of how many, I put it by seats, how many seats were available in the world at any one time per year. And you can see that there is a very marked shift in increased capacity somewhere in the mid-'80s, and that had to do with large tourist submersibles. What this does show is that a lot of these submersible regulations came around in the 1980s. 1990, ABS had a major publication of their safety regulations or safety rules. And this shows that, on the next slide, that we've gone from what we consider the heyday in the 70s, where there was maybe 1,900 solar dives per year around the world. We've hit somewhere around 50,000 a year. That's a very large change of order of magnitude. And maintaining safety throughout, and we have a record of 50 years without a single fatality until Titan, it does indicate the power of our regulation, the system we have in the rules for designing safe submersibles. Someone might make the argument, yeah, well, you don't have any incidents because no one's using them. No, this is a very large change in use. So we know the system works, it has proven, and the design regulations we have work. By the late 90s, written in the introduction of the NVIC, it says, look, we are aware there's something happening over here. And this slide over here shows what the market looked like in 1993. And in 1993, the market consisted mostly of research submersibles, military government types, and a new emerging technology, which was a large tourist subs. This graph over here shows how many subs were in operation by year. The green line shows a very steep increase, and that is the number of tourist submersibles that were coming on the market. This was of market interest and importance to the U.S. Coast Guard. Says we need to address something like that. You can see the curves for research and other submersibles are fairly flat. Go to the next slide. This is what the submersible population looked like. It was equally split between tourism, research, and government. The other category, as written in the preamble to the NVIC 593, is interesting to read. It is a public document. It is available to everybody. And it does specify small submersibles. Yeah, they're out there, but it's really nothing of significance, and we're going to ignore it. I put this slide up there. This is the preamble of the NVIC 593, which does say that this circular provides guidance relative to the inspection and certification requirements for submersibles, primarily those carrying more than 6 passengers. So it was very much with the intent of, okay, these tourist, between the terminology of tourist submarine, passenger submarine, there is some morphing over here. The language being used is about, allow me one more, go back one step, please. It says at the bottom, together with other recognized standards, and until new regulations become necessary, this document is considered to be the best available guidance to facilitate industry while ensuring passenger safety. I'm highlighting that because the landscape has shifted. We are not where we were in 1993, and I do believe we're there, where it says maybe we need to look at that. This is the first day of the rest of our life. We need to look at that. Next slide, please. This is to point out in 1990, ABS published the rules for building and classing underwater vehicles, which include specific requirements for passenger-carrying submersibles. Well, implicit in over here is that we knew that other submersibles existed before. The feature or the emergence of passenger-carrying tourist submersibles was something new that were being addressed. So I am reinforcing the fact that the other submersibles existed before the tourist submersibles. Next slide. So just to be really clear, what is a tourist submersible, passenger-carrying submersible? That's what it looks like. They are generally very large submersibles that can carry a large number of people. They do not go very deep. They carry people generally no deeper than 150 feet, and it allows people to have a first-hand view of what happens underwater for real. So we're coming to the NVIC 593 and the emergence of the tourist submersible. After 593 was released, the Passenger Vessel Safety Act of 1993 was signed into law and implemented by the NVIC 794. This made a modification to the guidance that was produced in 1993, which was a result of many years of study from multiple agencies that came up with a number of categories, identifying categories of vehicles, submersible vehicles. The new modification required that any submersible with one passenger or more had to comply with all the subchapter T tourist submersible requirements. It's quite onerous. This is like saying your Cessna 172 has to have the same inspection as your Boeing 747. Is it safe? Probably. Is it practical? Not very much. Research, now, what happened with that? Research subs took exemption from this, and they said from the nature of their work. It's like, nope, it doesn't apply to us. Navy and government says, no, we're exempt from this. Private home-built submersibles, this doesn't apply. Everybody in this country still has the right to build their own submersible and go dive it. This is precisely what Mr. James Cameron did. He did not class as submersible, but he was the only one on that vehicle. He could do it how he wanted. So it's perfectly fine. You just can't have and ever take anybody else. So home-built submersibles have a standing exemption. Tourist subs were fully addressed, rightly so. The code works. All other future submarines, none considered to exist at the time, would then also be seen and treated as tourist subs as defined by passengers. And that created a problem. Next slide. Now you can see what happened in the industry since the red dotted line here shows 1993, the release of the NVIC. And you can see that the meteoric rise of the tourist submersible completely flattened out. The market was saturated, and you can see from 93 onwards, both the research submersibles and the tourist submersibles, there was quasi no growth. However, the other submersible, which was considered zero, has a very steep rise in the number of vehicles. Next slide. The first picture of showing what a tourist submersible looks like, saying mapping all other submarines as a tourist submersible, that's a reality of what the industry looks like today. It is very wired, every size, shape, and applications. Next slide. If we look at the population and compare the two, in 1993, where it was one-third, 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 the new production from 1994 to 2017 shows that 68% of all new production is the other category that was considered non-existent in 1993. Now that slide tells us we have an issue, because that other category is completely unaddressed in the NVIC today. Next slide. So what happened? All small submersible manufacturers defined their vehicles as not tourist subs. Everything revolved around the definition of passenger for hire and created untold legal wranglings. We have way too much precedent on trying to figure out what the definition of a passenger is, and you're very familiar. The problem is that the U.S. Coast Guard officers and port captains were unable to resolve this ambiguity. It is just too complicated. This ambiguity and variances in adjudication from port to port, and that was the power of the captain of the port, left even greater confusion. Most operations made general exodus outside U.S. waters, including Mr. Paul Allen, who tried very hard to find a working solution. We had an ally in Mr. Allen to try and have his submersible operate in U.S. waters, and even he gave up, and it wasn't just because of money. It didn't take too long for the industry to realize that the key was to just find an exception, just like all the other sectors had done. Well, if research took an exception, Navy took an exception, government takes an exception, science takes an exception, private takes an exception, well, it doesn't have, you can imagine how the creative powers are being redirected to try and find another exception. And what was the exception is find a variance around passengers for hire. And this is exactly the approach that OceanGate took. The attempt of using mission specialists was to take exception to passengers, and it turned out that they succeeded because they were allowed to dive with Cyclops 1, with Antipodes and Titan under the carriage of mission specialists. But it was because it was a condition created by the de facto acceptance within the industry and the U.S. Coast Guard that you could operate as general governance of the industry through exceptions. That's a problem. Next slide. What do we know today? The submersible industry has shown an exemplary level of safety and diligence for safety over more than 50 years. Operators, owners, manufacturers have exercised stellar self-discipline as stakeholders for safety. In 1990, 1993, the submersible world looked like it would emerge with a major population of large tourist subs. Based on limited small submersible activity in 1993, it was perceived that small submersible applications would be overtaken by the robotic and drone technology. I've been at this long enough, people told me, why are you dealing with a dead technology that's never going to go anywhere? The strategy implemented by the Passenger Vessel Safety Act and NVIC 794 to treat all submersibles as tourist subs has failed. Managing governance of submersible through exceptions from tourism sub-centric regulations and misinterpretation of passengers for hire has led to an extraordinarily difficult for small submersible vessels to operate in U.S. waters. The submarine industry will continue to grow and requires diligent governance to ensure growth in an orderly commercial framework while ensuring public safety. Small submersibles are not going away. It is part of the national infrastructure of every economy to help manage our natural resources, coastal and in deeper waters. This type of access is just a natural continuation of our technology, and we never thought we had to worry about a new mode of transport. Well, we are here. These are the early stages, but we are at an inflection point, and we need to do something. And whatever governance, with all the good intentions in 1993 was intended, it is not working anymore, and we need to look at it. It's a complex situation. It's a complex industry. There are a lot of issues to play. There is no single answer. It is only collaboration between all stakeholders, and that includes industry manufacturers, operators, owners, and the regulators. It is part of our mission to continue our annual conference that we do every year to bring the entire world community together. And this is not just an American U.S. Coast Guard problem. It is a state problem of every country that is going to struggle with what do we do about those pesky submarines. They're not going away. So whether it's Canada, France, UK, Spain, whatever country it is, the states will have to come up with some means to manage it. How do you govern it? You have the option. Public safety can be served by saying the zero solution. We will forbid all submersible activity in our country. It is a safe solution, but the country will then also forego any sort of economic impact. It is a balance between the two. The United States Coast Guard regulations we have in place today, as released originally in NVIC 593, identifying different categories and finding the right amount of adjudication on it, was a good step. I think it is a good basis. Where are we? On the challenges, how do we go there? The innovation is at the core of the submarine industry development, and it's for many other modern economic sectors. We cannot go away from innovation. It takes an increasingly high level of knowledge to fully understand the risk associated with new technology. No state can expect its citizens to have the requisite knowledge to make a personal assessment of risk when dealing with something as complex as a submersible. The idea of a citizen making a decision based on informed consent is not realistic. Cannot be. The only option for the state is to make high-complexity technologies accessible to its citizen, is to provide third-party vetting according to accepted national and international standards. The self-discipline of an organized industry is a sign of strength and a positive value, with all collectively adhering to known safety standards and traditions, as are all stakeholders. What self-discipline in the industry cannot achieve is protection against a rogue agent. Protection from such activities can only be adjudicated by the state as an institution that cannot be taken to court for defamation or other intimidation devices available in a free society. The state authorities that regulate access to the ocean are the last domino standing. It is assigned by the state as part of the duties and responsibilities. And that must be very clear. There cannot be any ambiguity, and we must clarify that. Recommendations, the NVIC needs to be reviewed and updated. The certification process needs to be made simpler and clear. Classification societies should be authorized to perform the technical design verification, and classification societies should be responsible for construction survey, testing survey, and annually inspection service for smaller submersibles, and here it's 6 or less. No state has the ability and the budgets and the resources to create a new department to verify all these things. We don't need to. They are existing, they're international. The class societies are international NGOs. They can provide that service. But it takes care of the design and the inspection. The U.S. Coast Guard can recognize a small submersible in good standing if it is active in class. Because when you're active in class, you must have annual surveys, you must have reports, and you must log everything that's happening. What we do, and I'll just share that, this is the last slide, is at the moment we build quite a few submersibles, private submersibles, that go to owners of large yachts. If the yacht is registered to the Cayman Island, they can only put it on the yacht if the submersible is also registered in the Cayman Island. This is the Cayman Island Shipping Registry. We will build the submersible to ABS class. They will go under sea trials. We will perform all the sea trials with the surveyor. ABS will survey all the activity. On the final sea trials, we will invite the Cayman Island Registry representative to attend the sea trials as much as they want with ABS. After we complete the ABS test dive, we're generally talking about a week's worth of activity with ABS. On the last day, we will stay in port for one more day to do any test that the Cayman Island Registry would like to see. It works very well. It is not a big imposition on a manufacturer. What that does is does two things. First, it gives us a class certificate. We have full certification on classification on submersible, and it gets us registers with the Cayman Island Shipping Registry, which understands what that registration number means because they've witnessed that it has class. We are fully covered. If the Cayman Island wants to know what is that submersible, they have all the records, including the classification societies. And as long as it stays in class, your registration number has something. There is no reason we cannot do something like that with the U.S. Coast Guard, which requires very little department build on there, where while we're doing a class survey, the Coast Guard officer attends, and you can do an extra day or two to perform whatever test is required by the U.S. Coast Guards to verify this is all good. For small submersibles, this works. For large tourist submersibles, we need to retain the certificate of inspection schedule per the current NAVIC, which is greater than 6 occupants, with annual surveys and periodic inspections of operations as it is today. This is working. We don't need to change it. The U.S. Coast Guard should recognize multiple classification societies, perform classification of U.S.-built submersibles. That's really important. The U.S. Coast Guard cannot create a monopoly for the verification of submersibles. But it's all part of IACS. IACS is an international association of classification societies. Every state, and it's not just the Coast Guard, every country can pick which classification societies it wishes to have as registered agents to do the design and the construction. It is then also responsible for verification of the operations side. And the operations has to do with all the surrounding post-delivery issues that come with a submersible. Just because you have a safe submersible doesn't mean you can do silly things and not pay attention. And that has to include operational inspection requirements, minimum operation inspection requirements, maintenance requirements, safe emergency procedures, having enough research on sites, and most importantly, it also has to dictate what are the standard baselines for a minimum training for a pilot and for the crew and the maintenance. There's a list. The NVIC does touch on this. And we do have a problem today because some owner who doesn't know much about it will find out, well, how much does it cost for training? It's like, well, they say, oh, it's so advanced, you can get trained in 2 days. I mean, our program takes about a month, and it's a lot of work, and it's a bunch of money. It's like, well, one of you two is not telling me the truth, and it's probably you because you're making a lot of money out of it. It's like, well, no, you don't understand. It's like, you're right, I don't understand. Who is the adjudicator finding out what are the proper requirements over here? These are issues of top-level governance to deal with an increase in the production of underwater vehicles. They're not going away. We have enough experience. We have tried things, and the U.S. Coast Guard NVIC navigation rules is at the tip of the spear here. There is an opportunity to lead and to come up with a template that other states can benefit from. We do need to organize something at an international level, like Mr. Thomas was saying, at the IMO. We have regulations at IMO, but it doesn't work very well from top down. What we need to do is most states need to find a practical solution on how to handle this technology from country to country. And if everyone is doing the same cut and paste off a basic baseline, we have some commonality across. How do we manage activity in international waters? That's a problem. But what we can do, you cannot, I've said it before, piracy has been a 2,000-year-old problem. It's not going away. You cannot regulate, you cannot fight it. But what you can do is you can prevent access to international waters if it doesn't look proper. And if an operation that doesn't meet the requirements say, okay, well, you're going to have to leave from Murmansk to go to your dive site, well, so be it, but it's going to cost you a lot of money. But you're not having access to international waters through a civilized port. So there are ideas. We cannot save the entire world, but there needs to be a change. There is too much ambiguity in the current way we had. And we have found that over 30 years. It was with all the best of intentions in 1993, but the amount of legal wrangling we have and the confusion that we have within the Coast Guard and the public and the operators has created a black market for people to trying to find ways around. And what is the benefit for industry to go along with that? If a small submersible that is classed, less than 6 people can be classed, and the U.S. Coast Guard agrees to register it as a small submersible and have full access to the documentation, a couple of things happen. One of the biggest problems that occurred to me when I heard about the Titan problem is anybody trying to help the Titan was handicapped because nobody knew what the configuration was. Nobody could look up at their copy and say, okay, what they put on the comm system? What's the configuration of the ballast system? If you are classed, if you are registered, some of these informations are available to the rescue team. That is just on a side note. But the benefit for everybody to go along is if we can build small submersibles that are classed, they all are anyways, and we can get a registration from the Coast Guard, and that is now designated as a safe technology in a vehicle to operate in U.S. waters, regardless of who you put inside, the passenger thing goes away because the passenger and the scientists or the Navy person, they're all the humans. You are covered. These vehicles now become productive in society and they can actually do some work, and there's a lot of work to be done. The reason it's not is because it's too confusing.
Thank you, sir. I appreciate the feedback
Thank you.
to the Coast Guard. I do want to ask one follow-up question from your presentation.
Yes.
Of all the submersibles that you've produced, are all of those registered?
Yes. Registered with the Coast Guard?
Registered with a state or a country?
I don't know, sir. This is something that's usually tied to the ownership of the yacht that will go on to.
If you would check, it would be interested of the board to know if your vessels are all registered with a flag or a state.
Yeah, there'll be a mix. It'll be a mixed bag.
And by that, you mean you're sure that some are not?
Yes.
Okay.
Well, because the states will not have a mechanism of registering it.
Okay. So they're not registered because it doesn't fit the mold of what they would register?
It's like Mr. Stanley was pointing out yesterday, right? It's like, what did he say? He says, what is a government inspection? And he said sporadic. It's like, well, okay, it depends. There is an infrastructure missing worldwide, and it's not because of bad intention, because it's complicated. And it is the intent as directing, and one of the direct mission objectives of our World Submarine Organization is bringing the community together, come up with a consensus standard that we can say, look, this is a decent template based on best practices from industry that a state can use to start forming a structure on how to manage the flow of submersible, and it would include a registration process. The question is, what do you put in the registration? Well, the classification papers is an obvious.
Yes, sir. Thank you. And since you mentioned Mr. Cameron's deep sea
Yes, sir.
submersible, I want to just make a note for the record that the Marine Board did interview Mr. Cameron. We have a preliminary interview that will be part of our record. And in that interview, he detailed the extensive testing that he performed on his submersible before doing his solo dive to the Mariana Trench. So that's something that will be available publicly when we produce our report. At this time,
Mr. Chair, just to correct, so I'm not misinterpreted. Yes, there was extensive testing done. I'm just saying for definitions, classification has a different term. So that was only the comment I made.
oh, yes, sir, I just want to say there will be,
Very good.
the information on the exact testing he did will be available in our report as an appendix.
Excellent.
At this time, are there any further questions for Mr. Kohnen? Mr. Commander Whelan?
Mr. Kohnen, did you ever have any conversations with Mr. Rush regarding OceanGate operations with their submersibles and notification to the Coast Guard?
No.
Thank you.
Mr. Muse?
Your presentation answered most of my questions. Thank you, Mr. Kohnen, for that. Has anybody sat down and compared the our NAVIC versus other flag states? Is there a study out there and say, all right, UK requires this, France requires this? Has anybody sat down and compared those to find the best practices for?
Yeah, that's on my desk as Project 83.
right.
It is, no, it is part of the activity. We had a very interesting meeting at the annual conference last year discussing all that, and the international participation in the interest in all that is very high. And I think at this moment, it's very much something that we ought to be doing and provide internationally to people to understand what are the equivalencies. But we know what these rules are between France and the UK.
Can you touch briefly on any Canadian regulations or what position have they taken, if any?
Well, I being dual citizen and Canadian also, I know Canada is watching, and the message is to Canada as well. Whatever I'm suggesting for the U.S. Coast Guard applies to Canada also. And we do full-heartedly invite them to participate in our annual conference and sit around the table and hash this out. This is done among everyone. I have talked with them, and there is an acute shortage of any clear regulatory language within maritime affairs in Canada at the moment, and that's a problem. We hope to be able to help our colleagues up north to amplify on those.
Okay, thank you again for your testimony today.
You're welcome.
Are there any further questions for Mr. Kohnen at this time? Okay. Commander Whelan?
apologies, it's just a follow-up to Mr. Muse's question. Are there any other countries that you're aware of, or flag states that you're aware of, that have this regulatory schema in place that you had mentioned?
No.
Okay, thank you.
The U.S. Coast Guard leads at the moment.
Thank you.
Sir, do you have any final facts to share with the Marine Board before we adjourn with your testimony?
I appreciate the offer, but we're out of time.
Thank you, sir. If you do, you can submit a written statement
I
later.
understand.
Mr. Kohnen, thank you for your expertise and feedback during this today's testimony. You are now released as a witness at this formal hearing. If I later determine that this board needs additional information from you, I will contact you directly. If you have any questions about this investigation, or you'd like to provide any further information, you may contact the investigation recorder, Lieutenant Kelly Steele. Thank you again, sir. We will now take a brief recess and reconvene at 2:50 with our next witness, Mr. Bart Kemper.
Thank you.